How exactly the patents are processed? What are the steps through which your patent application is processed? To know more, watch this video. So patent can be filed as a provisional application or a complete specification. Provisional application should be filed in case you need some breathing time to develop your invention. Still you have not finalized your product. Still you need some time to do R&D and come up with the final product. In that case, you can file a provisional application. The provisional application should be drafted in such a way that it covers multiple aspects that may come up while completing your invention. Provisional application should not be narrow enough to claim or to write something which is very specific. While drafting complete specification, those things may not be the part of your invention. So the complete specification can be narrowed down to a portion of a provisional specification. Provisional has to be a little broad. Okay, so when your product or process or the method which you are intending to patent is not yet finalized, in that case, to secure earliest priority date, you can file a provisional application. Advantage of provisional application: from that date onwards, if anyone else files same or similar patent application in India, you will be given the priority. So any application that is filed after your date will not be given the priority. So you will be given priority in case there is a conflict. But provisional application is restricted to Indian jurisdiction or a specific jurisdiction only. It is not applicable to the global system. Means, for example, if you have filed a provisional application in India, it does not mean that that date is secured in US. No, it's not. You have to file a separate patent application in US. From that date onwards, the protection will start in US. Similarly in other countries. Okay. So provisional will give you a priority date only in the country in which you are filing the same application. If you want to take that priority in multiple countries, so on the same date, you have to file the provisional application in multiple countries. On same date, I'm just making it very clear, on the same date, you have to file the provisional application in multiple countries. So which is difficult. So unless and until there is a requirement to publish your invention, unless and until you are talking to the investors globally, don't file the same application in multiple countries on the same date. It's not required. Take some time, file PCT application, and then disclose your invention to the investors or the potential buyers in multiple countries. Before filing a PCT application, don't disclose your invention. Disclose your invention out of India or the entities or the person who can take your invention out of India. Okay. So provisional application. After filing a provisional application, you get 12 months of time to file complete specification. So you have to file complete specification within 12 months. It is not beyond 12 months. Within 12 months. So if you are drafting a patent application, if some external consultants are working on your invention, in that case, they should start at least drafting 1 month before. So 11 month is a deadline for you, 1 month for drafting. So you will get 12 months of time to file a complete specification. Once you file a complete specification, you cannot add or modify the draft. It's freezed. You cannot add anything to your patent application. Okay. Typographical errors or some expression changes you can do, but beyond that it is not allowed. Okay, so that is the reason you have to be very cautious while drafting and filing a complete specification. If it is not drafted correctly, it will be an intentional disclosure which will not give you any fruitful protection. Drafting complete specification and claim drafting specifically is more crucial for your patent application. Okay. You can skip the provisional application and you can directly file complete specification. Provisional is not mandatory. So after filing complete specification, your patent application go for internal scrutiny. There a classification will be allotted. It will be classified if it is related to any defense technology, which defense people think that it is crucial for India. In that case, it will be segregated and those patent application will not be published. After internal scrutiny, classification is allotted and then your patent application is ready for publication. Normally, without filing any early publication request, your patent application will be published after 18 months. So every Thursday after completion of your 18 months, The next Thursday, your patent application will be available on the Indian Patent Office website. Or you can file a request for earlier publication and prepone the publication. So you can file the request for earlier publication in case you want to show it to the world. If there is a requirement that you have to show a publication to someone, in that case only file a request for earlier publication. Otherwise, it is not required. Earlier publication is also required when you want to expedite the grant process. Without filing earlier publication, the startups, MSMEs, the female applicants or government funded colleges or government institutes cannot opt for this expedite route. So publication, after filing publication, you have to file request for examination. So request for examination can be filed immediately at the time of filing complete specification. We do file request for examination with the complete specification. So there is no need to wait till the deadline, because from the date of publication and from the date of request for examination, whichever is later, from that date your patent application gets into the queue. Okay, so the early the request for examination, the early your patent application will be examined. Okay, also you can file request for expedite examination along with the complete specification itself. So Form 9, Form 18 and Form 18A, everything can be filed together at the time of complete specification if you qualify for expedite examination. Okay, so after publication, it generally takes 1 or 2 years of time to get your patent application examined and to receive an examination report from the patent office. So that we refer it as a first examination report. If you opt for expedite examination, so within 6 months from the date of such request, you can expect the first examination report. You get 6 months of time to respond to this examination report. If you fail, there is no extension. Just make a note of it. If you want some extension, you have to file it before the expiry date of 6 months. While responding to your patent examination report, you also need to put your patent application in order for grant. If there are any other compliances that you have to do, those requirements are also cited by the examiners or the controllers. And after complying those requirements, within 6 months, you have to just file the response. If you fail, your patent application will be abandoned. Next, after scrutinizing your response, if examiner still thinks that something is still missing, he is not able to understand few things, in that case, he can request for a hearing. He can ask for a hearing. Okay, so normally it may take 3 months to 6 months of time from the date of responding to the examination to get a hearing letter. So in the hearing, nowadays it is an online hearing. So one-on-one you can discuss what are the problems, what he is not understood. You can explain your invention properly. What is the novelty feature? What is the differences? What is novel point? What is inventive step in your invention? And then if the examiner is convinced, after filing the response, he may grant your patent application or he may reject it if he is not convinced. So after the date of hearing, you get 15 days. It's not working days, only days. 15 days to respond to the hearing, file the hearing response. Thereafter, it will be rejected or it will be granted based on the examiner's judgment, controller's judgment. If your patent application is granted, you need to pay yearly maintenance fees depending upon the type of entity you are. In US, you need to pay for 3.5 years, 7.5 and 11.5 years. In other countries, it's every year. Okay, in US, it is 3.5, 7.5, 11.5 years. So during these years, only you have to pay the maintenance fees. So why this maintenance fees is charged? Because the government want to make sure that you are using your invention and earning something from it. If you are not using it, you will definitely not be in a position to pay this fees, correct? You will not be in the position to pay this fees. So there is a maintenance fees that has been charged by the government to make sure that you don't unnecessarily take protection and keep it to yourself. If you are getting protection, you have to pass on the benefit to the society. If you are not passing on the benefit to the society, that is one of the reason to revoke your patent application as well. If your patent application is not worked for 3 years, so the third party can ask for a compulsory licensing or they can also ask for revocation. If your patent application is not working, means you are not manufacturing and selling the product. In that case, you are not eligible to take any legal action against the infringers. Just make a note of it. If you are not manufacturing and selling the product or process that you have patented, still you are not eligible to take legal action, file an infringement suit. You can ask them to take a license. Your case will not be accepted by the court. Just make a note of it. So before grant, any interested party can file a pre-grant opposition if they think that your patent application should not be granted based on the evidences they have to provide with an affidavit. After grant, they get 1 year of time to file a post-grant opposition to revoke your patent application based on the patentability requirements that we discussed earlier. And thereafter, if the third party, if any interested party wants to revoke your patent application, they have to approach High Court. Okay, and if you think that your patent application is rejected, which is wrongfully rejected, you can ask for a review petition. If in the review petition the controller still rejects your patent application, you approach the High Court. So this is the entire process in which your patent application is processed. In India, we call it first examination report. In US, it is called office action. In India, there is a hearing. In other countries, examiners are normally available on call. They call it first office action, second office action, non-final office action, final office action, and allowance letters. So generally, the examiners are always available for a call. That is not the case in India specifically. That is the reason they schedule a hearing. So I hope you have understood this process completely. If not, comment in the comment section. We will clarify if there are any doubts. Okay, and don't forget to like, subscribe, and share this video to the people who are inventing. So keep inventing, keep investing, and keep earning. Thank you.